In terms of subject matter, I've possibly got the broadest, longest and biggest subject matter to deal with in 40 minutes that I've ever had to deal with. So do bear with me. I'll go as quick as I can. However, there are certain types of jargon that I have to use, and hopefully today I'll educate you in some of that jargon. Moreover, trusts have been around for a long, long time. That is Sir Richard Whittington of Dick Whittington fame, of Panto fame, and believe it or not, when he passed away, he was the 4-time Mayor of London, but when he passed away, he put his wealth into a charitable trust. Now, there was some trust changes in 2013, where for the first time ever, we were able to see what was inside of the Dick Whittington Trust. To give you an idea, the assets were kind of properties and shares and cash, but it was worth £1.3 billion.
Oh, no, it wasn't.
Nice try, nice try. So in that sense, trusts aren't just for a short period of time, they can be potentially forever. So my job today is just to demystify some of the jargon, some of the words and some of the complexities that are perceived by people that don't understand what they can do. So, what's a trust? A trust is something very simple. We had this all laid out earlier, but now I have to stand still, bear with me. So a trust is very simple. I own something, and that something could be anything. It could be property, cash, shares, a bottle of water. And what I want to do in my lifetime or on my death is I want to pass this asset to a group of other people. Now that group of other people would be beneficiaries. But what I also want to do is task individuals to make sure that they follow my wishes, and they're called trustees. So here's my asset. Jodie is my trustee, and as my trustee, I want her to look after it, nurture it, make sure it's okay, but I want her to distribute it to my beneficiaries. That's a trust. Simple as that. No more complicated than that. And yet, the complications have arisen through legislation changes, tax changes, governmental changes, laws, and so on and so forth. But as long as we understand the process of owning something and wanting to move it to someone else, it's as simple as that. Right, job done. When's your next? No. Okay. So, what we're going to do is move an asset. There are some key components to the trust, and there's some key roles and responsibilities within that. So again, just to expand a little further, the word is settler. That's me. That's who I am. I own the asset. We have a trust deed. Now that's the roadmap. So that's the rules, the regulations, what I need people to adhere to, how I want it to be looked after, who I want to benefit from the assets. We've got our trustees, so the people we like, well done Phil, the people that look after the trust, manage the trust, make sure that the rules are adhered to. We've got our trust fund or our trust asset. Our trust asset is our bottle of water. We need a trust period, and that's really governed by UK law. So Scotland's slightly different, but primarily between the UK, a trust can last for a couple of years, or it can last anything up to 125 years for a personal trust. If it's a charitable trust, i.e. Dick Whittington, it can last for thousands of years, assuming that assets within the trust are still there. Finally, we've got the beneficiaries. Now the beneficiaries, depending on what type of trusts we look at, can change over time and can be removed. So what are the benefits of a trust? The benefits of the trust are really those three key components: control, protection, and flexibility. So when we look at control, we're really focusing on our trust deed, our bit of paper, our roadmap, telling our trustees where it needs to go, who it needs to go to, and how it needs to be looked after. The protection is primarily whilst you're alive and then potentially while you're dead, ensuring that you've got the right trustees looking after your assets. And the flexibility is really common sense. With all of these words, with all of this jargon, with all of this legalese that gets wrapped around trusts, common sense normally prevails. If we have a beneficiary or a class of beneficiary that require something, the trustees are obliged to make sure that the beneficiaries are looked after. What we're looking to achieve from a trust is, a personal trust particularly, is mitigate. So we're trying to mitigate something by putting the asset into the trust. Now that can be protecting people from themselves, that can be making sure that the asset is looked after and nurtured correctly, but more so in the current form that we find trusts, we're trying to mitigate inheritance tax, the remarriage and divorce issues that go with bloodline planning, creditors, bankruptcy. Again, not suggesting you're going to go bankrupt in the room, but the children and generational planning. Now, there's 3 types of trust. And again, excuse the acronyms. I've just got to use them because, again, if you come across them, then hopefully that's something you can take away from today. So we've got 3 types of trust, primarily. There's lots of nuances and there's lots of differences, but there's 3 main types. We have a bare trust, we have an interest in possession trust, and we have a discretionary trust. I'm just going to give you some examples in terms of the trusts themselves and how they're applied. And I wouldn't be at all surprised if people in the room don't already think, oh yeah, I've heard of one of those, or I've come across one of those. Now, a bare trust is primarily used for children or grandchildren where the settler, so the person with the asset, wants to make sure that their generation and generations beyond them are looked after, normally with university fees or education fees, whereby they set aside some money for their children, grandchildren, and they specify that they want it to be used for education or deposits on a house or something of that ilk. However, with a bare trust, it's really simple. Once the settler gives away the asset, they lose complete control of that asset because it's no longer them or theirs. They ask their trustees to manage that asset on behalf of the beneficiary. Now, with a bare trust, that beneficiary is totally entitled to that asset, absolutely, at the age of 18. This used to be very popular. Children, as they've decided that they want to get slightly older and less responsible, the older they seem to get, people have decided that 18 isn't necessarily the right age to pass across the assets that have been put into trust. So what we have seen is where they've specified university fees at the age of 18, if they become absolutely entitled to them, you're finding that university fees are not at the top of the list and fast cars and lavish lifestyles might be at the top of the list. So the next one, interest in possession. Now, again, this is normally set aside in terms of a trust within a will, whereby you would give someone a life interest in the asset. So this could be a property, it could be an investment portfolio, and moreover, what we see is this one is used quite regularly when there are 2 marriages and then 2 sets of children, where the spouse wants to make sure that the surviving spouse is looked after once they've passed away. However, they want to make sure that that surviving spouse has access to the income and or can live in the property for the rest of their life, but the capital and the assets are then passed on to their own children. So again, we see that quite often. Finally, now this one, a term of discretionary trust. There are many, many variations of discretionary trust, and we could be here for hours. So I'm really just going to give you the highlights in terms of discretionary trust. It is the most flexible, it is the most powerful, and it provides us with the best scope to help mitigate inheritance tax bills, marriage or remarriage and divorce issues, bankruptcy and creditors. So moreover, since kind of 2013, this is the most popular type of trust you will come across today. The main benefit being that the beneficiaries, there is no entitlement to an individual. you tend to specify the beneficiaries as a class of people. Children, grandchildren, technical term is issue and remoter issue. So we find that because there is no entitlement, that you can help mitigate, you can stop the inheritance tax issues, the bankruptcy issues, and so on and so forth. There is one that you may already have come across, and you may already have. If you have written a will, and the will was set up pre-2007, 2007, October 2007, you may find that you have within your will a discretionary will trust. Now, it was primarily set up as an inheritance tax planning tool to make sure that on first death, the individual didn't lose their inheritance tax nil rate band. And that nil rate band was £325,000. What happened in the Finance Act in 2008 was that they removed the need to use the first nil rate band on death, and that you had an interspousal transfer. Jargon's ridiculous. You had an interspousal transfer. In other words, you could pass your allowance from your civil partner, your husband, your wife, to the remaining spouse, and when they died, you could claim both together. So since then, we've not really seen discretionary will trusts in a will. Moreover, what it hasn't taken into account of, and if you do have one of these in your will, I would suggest you go and speak to someone to get it reviewed, is it doesn't take into account the new legislation with the residence nil rate band. Now that's where you pass your property on to your children, and you can claim a further additional £125,000 today, personally, in inheritance tax allowance. So, I could go on for hours with that one. That's the most one, and we have the most variations of that one when it comes to looking to help to mitigate the problems that we find when we come to financial planning. The charitable trust, you can set up a charitable trust yourselves in your own lifetime. And the reasons that people do that are very much like Dick Whittington. Rather than just bequesting a sum of money to a charity and having no control over it, you have the control. You set the roadmap, you set the terms of the trust deed. So that's why people set up charitable trusts. Now, this is possibly the most important thing when it comes to trustee responsibilities. So we've named the settler, so I've passed something off, and I've given that asset to my trustees. This is the most important thing for trustees, their responsibilities and duties. They are obliged to look after the beneficiaries. They are obliged to make sure that they are cared for. They are obliged to make sure that the funds are invested. So as trustees, what has to happen, it sounds really obvious, is read the trust deed. You'll be really surprised the number of times that we come across people and they say, well, I've got this trust, I'm a trustee, I don't know what it does, don't know what I should be doing with it. It's their obligation, their responsibility to check it. The beneficiaries under any trust deed have that absolute right, and as a consequence there are many court cases where beneficiaries have taken trustees, particularly corporate trustees, to court and won. We're then looking at making sure that the trustees are responsible for the reporting issues, filling in a tax return, making sure that they pay the taxes on time, and so on and so forth. How am I doing? I'm good, all right, okay. Finally, trusts and Jess is in the corner, she's in charge, she's got the watch. So, finally, trust and taxation. Yeah, beware. With every nuance, with every variation, with every different type of trust, there's a different set of tax rules. That's a whole nother ballgame, which is why, moreover, people come to us. People come to us and the likes of us in terms of financial advisors and accountants to try and fathom what they need to do. You don't need to be the experts. If you are trustees or you are beneficiaries, read the trust deed. You don't need to be experts in terms of the taxation. You're not really in control of the taxation in the sense that the government set down the laws. The Chancellor makes up the rules. Now, I think it's a case, yeah, so that's me done. We are going to have some questions, a kind of open forum in the end. I'm going to pass you back across to Jodie now in terms of context, if that's all right. So thank you.
So I'm just going to conclude by using Darren, who, as I said earlier on, has kindly agreed to let me use him as a case study to show you how personal trust might actually help you as individuals, and then cover a few frequently asked questions, and then at the end we'll go open forum and you can ask as many questions as you like from us. If there's anything you'd like to talk to us offline about or confidentially, we're also available all day. We'll be around over the next break and over lunch, so please feel free to grab us and ask any questions then as well if there's things you don't want to cover off in open forum. So as Kev covered off, we've got an asset, and the asset can be anything. So typically we get involved in people looking to protect cash, but that could be a property, it could be an existing asset. So anything at all, in theory, can go into a trust. And excuse the kind of rugged box, but this is your trust. So your asset goes into your trust. The biggest concern most people have around doing that exercise is the loss of control, because you are no longer effectively the owner of the money or the asset that you settle inside of that trust. So when I started work with Darren and Louise had 3 separate issues really. The first issue that they had was an inheritance tax problem. So they were looking to ensure that their estate was well structured and really planned as well as possible to avoid paying any unnecessary inheritance tax where they could. So that was kind of problem number 1. Problem number 2, or issue number 2, was how they ensured that they had sufficient money to pay for care going forward when their care costs were unknown. So I appreciate that a number of you in the room are going to be facing similar issues where you just don't know the future cost of care. So their concern was that they wanted to make sure their assets were working as hard as possible, but also that they did have the provision in place to allow for care to be paid for if it needed to be funded personally going forward. And then lastly, and this isn't uncommon at all in the world that Kev and I look after, was the fact that they'd both been married previously and both had children from separate marriages. So in their situation, they were keen to make sure that their assets passed on in line with their bloodline and that they had some control over where that money was actually going. So Darren had some specific requirements for the monies that were passing from him to his children, and similarly Louise was looking for monies to go to her children in a way. And in that instance, with those kind of needs, trusts work perfectly. What we were actually able to do was do a combination of different trust planning, so it wasn't just one trust. In fact, Darren and Louise have a trust each, and they also have some trust provisions written into their wills. But I'm just going to deal firstly with the trust that they set up at the time when we first started advising them. And those trusts do a number of things for them. Firstly, they have allowed for money that they had and assets that they had to work harder than where they were at the time, just being held in cash. So actually the eventual idea normally with a trust is that your bottle in this instance becomes more than a bottle, becomes 2 bottles or 3 bottles, so that you're passing on in the long run money or assets to children or loved ones or whoever that might be that have grown in value because they're working hard within the trust. So the trust that we set up for Darren and Louise was able to A, make the money, the asset work hard, and then secondly, allow them some provision to have monies come back to them if they needed it. So personal trust can be flexible in this regard to ensure that although you are giving up control, that money is the eventual ownership of your beneficiaries, there are provisions in place that allow you to have some access to that money should you need it whilst you're alive. And I think it's an important part to understand that you're not just completely necessarily passing an asset away. The benefit of putting it into trust now whilst they're alive was the fact that it started a clock running for 7 years, that once the 7 years had passed, the money that was put into the trust for them both were outside of their estates for inheritance tax purposes. So the personal trust was also able to target that need for them. No longer in the estate for IHT purposes, and all of the investment growth and the monies that were working within the trust will never fall back into the estate for inheritance tax purposes going forward.
After 7 years.
After 7 years, exactly, yeah. You're absolutely right. And then finally, because we set up individual trusts for Darren and for Louise, the roadmap that Kev was talking about is, again, really simply put, a letter. It's as simple as a document that you are in control of, that you write out to say, this is where I want this money to go to, this is who I'm choosing the money to be benefited to, and if there are any provisions that you'd like to have in place around the beneficiaries, you can do that within your trust deed or your letter of wishes that sits alongside the trust. And moving away just slightly from Darren and Louise, that actually, for some of our other clients, is incredibly useful where they have monies that they want to pass to children, for example, or grandchildren, where they don't, for example, necessarily want them to have it until they're older, or they may want the monies to be used or the asset to be used in a specific way. And it allows you to do those pieces quite straightforwardly and amend them. So we also are very much aware that the situation that you're planning for now may be very different in 5 or 10 years' time. So it allows you just to rewrite that letter of wishes effectively and change those pieces. So inheritance tax efficient, moving monies away from the inheritance tax issue that Dan and Louise faced. Good for allowing them some comfort and some knowledge that they did have the provision being made if they needed funds in the future for care. And thirdly, outside of the estate for all of the benefits that Kevin was talking about earlier. So in terms of, and we have to be really careful about this, in terms of care assessment, you can't be seen to put monies or settle monies into a trust if you are doing it to avoid paying for care. I mean, that's just a reality of legislation. They make it very, very clear, and we as financial planners will make that clear to everybody that we talk to. You can't be seen for that to be your primary driver. That wasn't their primary driver, and that isn't typically people's primary driver for doing that. It's an added benefit of a trust in certain circumstances. And in this instance, the primary driver was the inheritance tax need that we were looking to deal with. And often the primary driver is actually making sure that monies in the future pass to people that you want that money to pass to and is protected in the way in which it passes across. So I'm hoping that just gives you a little bit of context around how we use personal trusts. And although they do seem complicated and there are a lot of variations, actually the bit that really everyone's looking into is matching the right type of trust with your needs, and everybody will be different. So when I sit down and Kevin sits down and talks to people, absolutely all of you have a different set of needs when it comes to that, but quite often a trust can be just a tool that we use in our toolbox that can help to assist coming across and mitigating some of those issues that you face. The frequently asked questions that we come across, more often than not, revolve firstly around costs. How expensive are these things to do? How expensive are they to run? And how complicated are they? So I'm just going to hit those three, and then I'm going to go open forum and you can ask any questions that you like. In terms of costs, the costs vary from a few £100s to a few £1,000s, and the reality of why that varies is normally down to the issues you're trying to address and the complexity of the trust solutions that you need to put in place. If you were simply, for example, looking to make sure that if you were working and you had really large death and service benefits as part of your employment role, or you had life assurance or something like that in place, a single trust being set up to house that money, to stop it dropping into your estates personally, which is something we'd always recommend, would be very, very cost effective and straightforward to set up. Where you get into more complex needs, the cost escalates, but not to the point ever where you would expect to pay more than the value you're expecting to get from it. So again, sorry to pick on you, Darren, but I'm just going to give you the example. The inheritance tax savings that were being presented by the trust solution far outweighed in that situation any cost of setting it up. And that's always what you're looking for. There's got to be a value offset between the cost that you're paying versus what you're trying to achieve in doing the trust in the first place. Running costs vary on what this looks like. If this is a property or an asset that's harder to control, you do sometimes face taxation issues and ongoing monitoring and review issues on that. Again, not insurmountable, and what you'd be looking at there is what you're trying to achieve by placing the asset itself in trust. What we often try and do is make sure that whatever is the asset within the trust is as straightforward as possible to keep running costs as minimal as possible. You really, as part of setting up your trust, want to make sure that it's as simple and straightforward as possible to run on an ongoing basis. And then in terms of complexity and the nature of trusts, they are really, as Kev hit on earlier, as simple as you want them to be. If you know what your outcome is and you know what your objective is, there is a trust solution that will probably fit that. And then it's just about outweighing the benefits and the pros and cons of using that trust solution to meet your needs. So I think that's why I kind of start on this. It's an individual case by case just review to see whether or not they're suitable.